Hey.
Namaste, Hetep Her-Nebti. I'm here with attorney,
Edgar O. Moxie, yes.
yes, esteemed attorney of the Commonwealth of the Bahamas.
Uh,
Today we're going to discuss companies and how they are formed, including nonprofit and regular companies. Good day,
okay.
Mr. Moxie.
Good.
What is a company?
Well, a company is an association of people coming together, okay, with some objects in their mind, thinking that perhaps we want to gain, or it could be nonprofit, or it may be other purposes. So a company, but of course that company is incorporated and registered under the Companies Act 1992.
Okay.
So
Yes.
company.
And who can form a company?
A company can be formed by two persons or more, and two persons come together with a view that, okay, we're going to form the company, we want to have a memorandum and articles filed and so on. In the case of a nonprofit, it will be two or more individuals, not because you can have persons being legal persons as well. Okay.
And what documents would be required?
In order to form a company, the documents that you're going to require would be the affidavit attestation. Say, I sat here and I heard, I observed, or should I say, I witnessed that these persons came together to form a company. So you have your memorandum of association, you have your articles of association, you have your statutory declaration from the attorney saying a certain thing. Now, I mentioned to you earlier that two or more persons. There are a couple persons who are disqualified from becoming from forming companies. I think we want to backtrack and catch those persons who are disqualified, and that would be persons under the age of 18, so they haven't reached or attained legal majority. Okay, a person of an unsound mind. Okay, and also an undischarged bankrupt wouldn't be able to form a company. Okay, so as I said before, you have all those different documents, your article, your memorandum, your statutory declaration, maybe an attesting witness, and sometimes people go ahead and put in their initial meeting of the subscribers as well as part of their formation documents. Okay.
All right. What documents will be completed for the incorporation?
Okay, let us go in through the documents in turn that I've mentioned. Particularly, we'll start with the Memorandum of Association. For limited liability Bahamian company, okay, which is limited by shares, the Memorandum of Association will state certain things. It will give you the name of the company, okay, and with the word limited or LTD beside the name. It will give you the location of the registered office where that you want to serve documents that particular company. It will give you the authorized share capital. How much shares can you issue to the persons? For a typical Bahamian company, it will be 5,000, 5,000 ordinary shares at par value $1 each. Okay, and it will set out the objects or objectives of the company. In other words, why is it done? Now, oftentimes people just use to be in business to gain profit, end the story. So that covers the multitude of sin rather than listing specifically what the objectives are. And each subscriber, you would say how many shares that they are issued, the total number of shares issued to the subscribers, and you would say the value of those shares. So if it was 10 persons, you say 10 shares at $1 each, value $10 kind of thing. Okay. Now we can move then to the Articles of Association. Now, what is the Articles of Association? The Article of Association of a company is really how the company is regulated. Put another way, it's the terms by which the members agree to regulate their association or they're coming together as a company. So it will cover some preliminary matters. It will talk about the business of the company. It will talk about shares, lien on shares, transfer of shares, transmission of shares, forfeiture of shares, so everything about shares. It will talk about how do you get around altering the capital,
Mhm.
of the company. It will talk about meetings, annual
Right.
general meetings, extraordinary
quorums,
meetings, general meetings, quorum, everything to do with meetings
Mhm.
will be covered. Then you'd have the vote of members, how, the typical would be one member, one vote per member, right?
Right.
Okay, so you'd have that. Then you'd have directors and their powers and duties and
Right.
responsibilities, all that will be in there. Then you talk about perhaps the company seal, how it's going to be administered, when, and so when it's going to be used. There may be rotation of directors. There may be something on dividends and reserves.
Right.
For example, the company can't give out dividends more than
Then
certain
what is
amount,
there? Yes.
okay? And then accounts,
Keep it viable.
if you're gonna have accounts, if they're gonna be audited, et cetera, you may
And it
set
is
out.
advised that it be audited.
Yeah, that's a good thing.
Okay.
Yeah, you wanna have accounts, proper accounting.
Yes.
Provision is in there for that. And then of course, like notices, how much notice to give for different things.
Right.
All that would be contained in your articles, okay? And then, following the incorporation,
Yes.
yeah, there are some things that you're going to end up with. Once you've incorporated, you're going to get your certificate of incorporation,
Right.
okay, which says this is the company and this is the reference number, etc., the date of formation. You're going to go ahead and acquire a corporate seal,
Right.
that seal that we speak about, which is the hand of the company essentially.
Yes.
Then there are the share certificate register book, for those persons who you issue share to the subscribers and subsequent issues.
Mhm.
Okay, the company and then would then be able to go ahead and establish bank accounts, obtain property,
Right.
and so on, as we'll chat about a little bit later. Okay.
Okay. What about nonprofit
Now,
organizations?
if you're dealing with non-profit organizations, non-profit organizations, the memo would normally say that the members' shares are somewhat limited by guarantee.
Mhm.
In other words, each member says, I guarantee that if this company folds up
Right.
or wind up, I will pay, let's say $10, $15 per share for my one share, to assist in the event of the company, folding up or liquidating. Okay, and that amount that they undertake to contribute essentially represents their guarantee.
Okay.
So that's how it's limited by
Uh-huh.
guarantee. Okay, so you also have in the memo, you're gonna have the name followed by limited again.
Right.
You'd say the location of the registered office. You'd say each member undertake to contribute, again, given that
Right.
guarantee of how much they're going to contribute in the event of the company folding up. Okay, and of course the number of members initially that are subscribers and how many shares that were issued.
Is there a limit to
to
the
them.
subscribers? The amount of subscribers?
No, but people tend to not subscribe 20 people because
Right.
everybody has to sign.
Right.
So you can use a few subscribers rather than many
Right.
subscribers.
Okay.
Okay.
Okay. What are some of the factors in forming the nonprofit?
Okay, some of the factors to be considered in forming a nonprofit. As we said, the memo is going to set out, your name, your objectives, and your subscribers. But
Right.
all that, the articles, you want to
Yes.
know what is it that you want in the articles that really regulate that nonprofit organization. So in there, you're going to have things like the name, the vision, the purpose,
Right.
policy. Sometimes you have a policy position that you
Mhm.
want to maintain. Maybe doctrine, covenants,
Right.
okay, of the organization. Let's say it's a church. They would want to say right out, what are my doctrine, what are my covenants. Membership matters. How do you deal with membership matters? So there's a whole,
Right.
lot of things there with
Mhm.
membership matters. The leadership and organizational structure
Yes.
of the organization, you would want that in because anybody coming behind want to know how it was formed and how it's intended to be. Okay, then you have your board of directors, all their powers and duties and stuff. You
Now,
may
with
set that up.
regard to the amount of board members, would it be better to have an odd number instead of even, just in case?
Odd number because
Always.
yes, always. And then the chairman, he
Mhm.
may take the consensus of all, but he
Right.
may have that casting vote. So it's a good thing
Right.
if it's an odd number. Yeah, it's a good thing there's an odd number. So board and its functions, then we talk about officers and their functions, because you know, some of the chief officers like a secretary, sometimes you have a secretary and a recording secretary,
Right.
you have a treasurer, you know, and so on. You may offer positions like president, vice president, and all these, but certain functional duties you want to have in there as well. Then the term limits for office, that's
Right.
important, because
Yes.
some people figure in a nonprofit I'm stuck for life.
Yes.
But if you put a term in, it changes that, because then they are subject to an election.
An election and voting.
Yes.
Okay,
Yeah,
and they
yeah.
can't pass it on
On
to
to their children, no.
Okay,
no.
like we've had in certain cases.
No, you don't want that. Yeah, you want a term of office.
Yes.
Then you talk about meetings and elections.
Yes.
So there you go. So now in the meetings and elections, you get to,
Yes.
you know, what vacancies exist. You get to fill
Exactly.
those vacancies.
Mhm.
Okay, you may talk about the seal and how it's to be used or not used. You may talk about the accounts and provision for borrowing, because you know a nonprofit want to borrow too. So how do you
Yes.
go about borrowing? What majority do you need? How do you get guarantees if you need them? You know, anything like that.
Yes.
And then it's going to speak naturally about what in the event of winding up. That's when the little guarantee comes in, and that's where how do you wind up. And then, of course, you're going to list who are the subscribers once again in those articles.
Now, with regard to forming that company, that would be with regard to who can form, but take the same tact as with regard to the regular company. You have to be over 18.
Right, okay, yeah, those provisions would exist.
Same provisions.
Yeah, same provisions would exist.
Okay.
Okay.
And what is the checklist for applications?
Now, for checklists, there is one on the site, the government site, so there is a checklist. The application to register, initial vetting before forwarding, you know, because first of all, you send it to Registrar General, they do the vetting, send it through AG before you come back to you, right? And then there's the regular payment of fees. But some of the things that's in that checklist, it speaks to the registration form. You gotta complete that form. It speaks to your certificate of incorporation, organizational document, or constitution, which would really be your memorandum and articles of association. Then, of course, that declared purpose of the nonprofit, that has to be there. Okay, the identity of your controller and other members. The persons who are controlling the organization, their identity must be registered. Then there's proof of identity, which would be, you know, normally a utility or something to prove. The identity and then also the address. So you have both things there. So then you also have a register of directors. Who are the directors? Then register of your founding members. Proof of address is the other one. So you have the identification, which would be perhaps a passport, and then you have also the proof of address for the controlling persons and the initial subscribers. Okay, and oftentimes if you have an umbrella organization, for example, you're only a branch under something else, you'd want to indicate the umbrella organization as well. Okay.
Okay. Are there any compliance concerns with regard to nonprofits?
Yes. I'm happy you asked. Compliance concerns. Proper accounting.
Yes.
Proper accounting is required for nonprofit organizations according to the Act 2019. Under Section 7, a nonprofit organization shall not carry out its operation unless it's registered. Now, you know, there are a number of organizations who got caught. You know, the act comes into play and they're not yet registered, and then they have to hasten to register to be in compliance. And some of those would still be in process, and then proper formations, you know, in the works now. Okay, so that registration is important.
Do they have a charge for non-compliance of that?
Well, I don't think. I think they're waiting on time before they come hard on all of the, you know, for registration. But everybody is encouraged to be sure that you register early. Okay.
All right.
Then there's the issue of records as to purpose. A nonprofit organization shall keep at its registered office records that are sufficient to show purpose, objectives and the activities, right?
Right.
And of course, the identity of persons who control and direct the entities, okay? For example, your senior officers, your directors, your trustees,
Right.
and so on, all right? Another compliance matter would be an obligation to provide proper accounting,
Right.
okay? Now, in the earlier part of the legislation, it said financial statements. It's recently changed to say reliable financial records, okay?
Because
But
most could not find those.
but a controller of a non-profit organization shall cause reliable financial records to be kept at the registered office. Okay, so that's important. Then there's a section that speaks to section 22, speaks to the production of records. So what happens there? The registrar may require, okay, they may have grounds to require that you provide records, okay, and in such case you need to be able to provide records. So obviously record keeping is important.
Yes.
Okay, for the non-profit organizations. So and this sort of request for the information would often come when there's identification of some form of risk. There's some sort of risk involved. So the notice, the request, give me some, provide the records. One of the other sections of importance is reportable donations. Yes. Okay. So a nonprofit organization shall every 2 years submit to the registrar specific details of donations that are, for example, $50,000 or more. Okay, and that is whether the donations are lump sum or aggregate.
Right.
So there are ways around 50,000 by putting in 5 slots of 10, right? So you'd still have to provide the information, and then of course the next catch would be part B that says 10 largest donations. So you won't escape if you have certain amount. So you want to keep records of such donations, right? The report must be kept confidential by the registrar, obviously, because unless you're under investigation and the law requires them to render that information, that information will be kept current. Another provision that's important would be in compliance would be section 27 that speaks to supplying false and misleading information or withholding information from the registrar. So if information is required, a person must, who commits such an offense, for example, deliberately provide inaccurate information, withhold information when required by the registrar. Okay, a person who contravenes this section would be liable upon summary conviction to a fine not exceeding $10,000 or a term of imprisonment not exceeding 1 year or both. Okay, such fine and the term of imprisonment, so you could be penalized.
Now, basically, the person who would be the one penalized would be the controller of the financial records of that organization, or would it be the president and all of the directors?
The penalty, I believe, goes to the organization, but if you're going out of an organization, who are you going to? The head of the organization. So the controller, person who control the mind and will of the organization, that would be the one. That's the person going to be responsible to be sure that the records are kept, that you're in compliance. If something, if registrar require information that you provide. So, I mean, it's always good to keep, to have good housekeeping, to keep your records together.
And international donations are welcome for nonprofits here. There's not a stipulation.
There's not a stipulation, save and except for accounting. So in the event that you need to say. Okay. But you must be careful with international donations, source of funds. Okay. There's always this concern about, that's one of the biggest concerns, really, because if that international organization happened to be a terrorist organization, then what?
Yes.
Okay, anti-money laundering. You have to watch out for that. Anti-money laundering and terrorism financing.
Yes.
So be sure that you're not laundering
Right.
on behalf of an organization. Know the source of funds, be able to
Yes.
verify, and also, you know,
Even if it's third-party funds.
pardon me?
Even if it's
From
third-party funds.
yeah, you
Okay.
want to drill down to the source of the funds.
Okay.
Drill down to the source of funds. Be sure
Okay.
that you're not, fronting for somebody by way of money laundering,
Right.
or taking terrorism funds for some other reason.
Okay.
Yeah, you want to be sure of that. Okay.
And
Okay.
the consequences of incorporation.
Well, once you form a company,
Mhm.
there are a couple consequences. First of all, you form a company as an association of its members
Mhm.
and a person, a legal entity that is separate and apart from its members.
Mhm.
So people enter into agreement or enter into contracts with a company,
Right.
not the shareholder,
Right.
but a company, not its members, and conduct its business as a company.
Right.
All right, that's the first thing. Secondly, that company is now able to enter into contracts as a legal entity. All right. Oh, that company can sue and be sued. Okay. All right. That company can go ahead and own property.
Mhm.
That company can continue to exist. The concept of perpetual succession.
Right.
It continues to exist if 2 members or 3 members or 10 members die, for that
Right.
matter. It's going on.
All right.
Okay, perpetual succession. So the company continues to live on beyond members, the initial
Right.
members, and so on. And then, of course, that company will go ahead and delegate management to its directors.
Right.
So president and directors, you go ahead and manage,
Right.
but you render an account to your shareholders.
Okay, now with regard, say there's a company, you're a shareholder, there's case of divorce. How is that protected, the shares, or the company protected from a situation such as that?
The divorce in terms of a officer,
An officer of the company and a shareholder of the company.
profit, non-profit, doesn't matter.
Doesn't matter, right?
A divorce would not affect a company at all. Remember, a company is that group of persons coming
Right.
together, incorporated. A company is a separate legal entity on its
Right.
own.
Mhm.
So the fact that an officer
Right.
is divorced is of no consequence to the company.
Right.
Now there could be a little, if you have joint shareholders,
Right.
that would be okay. If the name on that share certificate says Mary and John,
Yes.
okay,
Mhm.
now that is a marital sort of an asset between the two.
Right.
So only when it comes down to their divorce, ancillary dividing up of assets,
Yes.
that matter, then the court, if they don't agree, the
Right.
court agrees as to how those shares will be allocated between the two of them.
Right.
So that's the case where it could, but again, that's shareholdership. It doesn't
Right.
affect the company.
Right.
Unless, of course, they're the sole ownership
Ownership.
of a single company.
Right.
All right, if it's only husband and wife own the company, the court still will tell them how to share it, how to divvy, when it comes
Yes.
to a divorce.
Right.
Okay, yeah.
And the same within a state?
Within a state, if multiple persons own,
Right.
yeah, but in an estate matter, you will ask, what does the will say?
Right.
Okay, if the will says it's allocated to
Yes.
somebody or another.
And
Okay.
if there is no will?
If there's no will and the person dies intestate, then you have to follow what the law says in terms of ownership of assets.
Mhm.
And in the case, like you say, shares in a company, the first thing would be spouse.
Right.
Okay, is there a spouse?
Mhm.
Then are there any children?
Right.
Okay, if it's only a spouse,
Mhm.
it goes to the spouse.
Right.
If it's spouse and children, half to the spouse, and the other half to the children equally.
Equally.
Okay, yeah, all right. Mm-hmm.
Thank you so much.
Good, my pleasure.